Okay, so here we are again, another court date, another court proceeding. And this is about a auto negligence case where things just went crazy. You all will be able to hear it when we get into the discussion. I filed a motion to vacate the underlying order that involved my case. So what we're going to try to do here is make it make a little bit of sense. Give me a second. Let me go ahead and fix this right here real quick. Yeah, much better. So now I'm gonna address a couple of issues, one of which is that the attorney engaged in fraudulent conduct. And this may come as a shock to some of you all, but you can see my veterans lapel pin. But the interesting thing is that the attorney used a VA doctor to conduct the compulsory medical examination. I wasn't aware of that. And then also during, and I can get into some more of the details in another video. Later on, I found out that the doctor worked at the VA when I went to go see him. So he treated me for the insurance company and then at the VA. Subsequent to that, the the attorney filed a pleading on behalf of the doctor that he did not represent, which is any attorney out there would tell you that's problematic because they didn't represent him, and he made false representations in his motion. I challenged that, and me and the judge, as you're going to probably see, we have a contentious relationship. But I did file a writ of prohibition, so I'm hoping that the second DCA will make her disqualify. And she actually disqualified herself from a follow-up civil lawsuit that I filed. So we'll see how this goes, and if we have any questions, maybe we'll take this up on at another time. So in the meantime and in between time, hopefully this will be something that people can pay attention to, and hopefully even call your Congress people, your senators, and say, hey, since when would it become okay for judges to let attorneys, I better take my flag now, let attorneys, let doctors for the VA work against veterans, and when did it become okay to let veteran attorneys also work on behalf of an adversary to the VA, which is in conflict to Title 18 U.S.C. 208. It's a financial conflict of interest. Nevertheless, we'll see how this goes, and y'all just take time to enjoy it. We got a couple more minutes, and I would appreciate commentary on this issue here. I don't even know how many times I filed objections or noted, asked for, actually made objections during the proceedings, but it was interesting. I'll tell you, it was definitely interesting. So we'll see how this goes, and we'll work with it from there as well. So I will be plugging in, and you all sit back and enjoy. Oh, hold on, I can't hear. So hold on. I can't hear anything.
Mr. Doss, can you hear us now?
Now I can hear everything. Yes.
Okay.
So I don't know what I might have missed the first time around.
You didn't miss anything. We were waiting for you. Okay. So Annie is the court reporter from, I'm sorry, did you tell me Esquire? No.
Your Honor, it's Vera.
Yes. Sorry.
From where?
Vera Text.
Taisha Scott?
I'm sorry, what?
I have a court reporter from Taisha Scott reporting.
I know. I sent her away because we have two court reporters. We only need one. So I sent her away. So Mr. Doss is the plaintiff.
Yes, you sent my court reporter away?
Right, I did, so that you wouldn't have to pay for her, and so the defense would be paying for theirs. So it doesn't matter because you both have motions filed. We have one official court reporter. All right, Miss Dr. Moore, you represent the defense, right?
Yes, along with my co-counsel, Mike Rowe.
Okay. Okay, great. So we should probably, I guess we could start with the motion to vacate and then we can move to the motion for sanctions. Go ahead, Mr. Doss.
Okay, well, I don't know if everybody's aware that I filed a writ of prohibition into the second DCA. I don't know if that would divest this court of jurisdiction in the immediate matter because of your denial of my motion to disqualify you, which would have been like my third or fourth one. So I don't know if it would be proper to move forward, but with that being stated, I'll object to the entirety of the proceedings until the second DCA has ruled on my writ of prohibition. Secondly, if you're going to move forward, I'll move to strike the defense's motions in opposition to the motion to vacate because they weren't filed within a reasonable time. I filed my motion to vacate, I believe it was in January of January 31st, in fact, of this year. She did not file her motion in opposition until sometime in September. That's not reasonable, even within the rules, even if the rules don't expressly state how many days. I will object to her motion, and even if Michael Rowe filed, they sent me a packet of stuff as far as their motions in opposition because of the untimely nature and late responses. I know we tend to disregard rules around here unless it applies to me. But what we're going to do is make sure that we stay in lockstep with what has been well established law, and that's not 8 months is not a reasonable time to file a motion in opposition, and she was served with that motion to vacate timely. As far as her motion for sanctions,
No, we're going to do it one at a time.
okay, so I will object to that as well. But as far as the motion to vacate, the issue.
Well, let me hear her response to your preliminary statements. Ms. McElmore or Mr. Rowe, who's going to argue with regard to the timing of the response and the petition for writ of prohibition, which was filed in the second DCA.
Deanne, you want me to take that?
Hi, Your Honor. I can take that, Mike, if you want. The writ of prohibition, the petition for writ of prohibition, it is my understanding that the second district has not issued a show cause order yet. There was no certificate of service on that petition, so we checked the dockets this morning. There's no show cause order on it, which means this court still has jurisdiction, which is our understanding of the law, as well as filing of our response under the rules. There's no time period for which us to file a response. In fact, we don't even, under the rules, are required to file a response. Our response is timely. It was filed timely before this hearing, which he filed in January, and we filed our response well before the hearing. Our response is timely, and it's just in opposition to his motion. Mike, unless you want to add anything.
And I would object to that.
Oh, that's it. Thank you.
And I would just object for that. Just have the objection note on the record that her response doesn't meet what would be a reasonable standard, and we can go into what that might be as to whether or not it's filed timely. But we can move forward and just address the the motion to vacate.
Okay, so let me just make a ruling before we do that. First of all, I have not been served with order to show cause, so I believe I still have jurisdiction. I can go forward. I checked the dockets as well this morning. Second, you filed a motion to vacate. There's no pleading requirement that any written response be filed to that. They could have just argued. They did file a written response, which was filed a week before the hearing was set on September the 10th. Now that's been over a month ago that you've had to review the response. So it's what they're going to argue today. You've just had advance warning of that. So there's no prejudice or problem with that. So we're going to move forward. So let's substantively argue the motion to vacate. Mr. Doss, go ahead.
Okay. As to the motion to vacate the order enforcing the judgment, there's a couple of issues. One would come about for the fraud on the court that was done by Mr. Rowe when he induced me into a second mediation conference after intentionally or deliberately omitting the fact that he was there, not for the issue of the Tuckers, but for the issue of trying to resolve matters that involve State Farm Insurance Company, the Department of Veterans Affairs, or the United States government, Dr. John Shim himself, and also Shim Spine. I've got the Shim Spine, whatever it is, LLC or whoever they may be, and I want to say State Farm as well. That in and of itself becomes extrinsic of fraud. Furthermore, the court issued
Well, he does represent State Farm. I mean,
but
that's the party that had the responsibility for defending the Tuckers, right?
I
So
understand that,
that's,
but I didn't sue State Farm. I sued the Tuckers, and I understand that the State Farm assumes the liabilities of the Tuckers because the Tuckers pay their premium, and because they pay their premium, State Farm is obligated to represent them up to the limits of their liability coverage. I understand that part. So if we want to say we want to exclude the State Farm aspect, it's fine. However, uh, when we went to the mediation conference, it was under the auspice of me addressing solely the incident that happened on January 16, 2017, which State Farm accepted liability for. And when we went to, and so that liability is not the issue. Uh, there are several other issues within the court, to include Michael Rowe's deliberate omission of the fact that Dr. John Shim, who he intentionally solicited, and his firm has a history of soliciting to perform compulsory medical examinations on behalf of State Farm, was also a United States government employee who worked at the Department of Veterans Affairs. Now, Title 18 United States Code Section 208 expressly states that a financial conflict of interest is a criminal act. I don't think we need to go into the weeds of that one right there, which is part of the substantive reason as to why I'm going to keep moving until either I get a United States attorney or somebody with the Department of Justice, either put him or Dr. Shim in cuffs for what they've done. Plus, Dr. Shim saw me at the VA after the compulsory medical examination without, and this is an ethical violation for a doctor as well, without disclosing to me when he saw me at the CME that he was a VA attorney. So, and I'm giving you some foundation. So we move forward. I file a motion. I file a subpoena Dr. Shim to come to a deposition. Michael Rowe, who does, well, Austin Rowe in basketball, ARB, I'll just state for short. ARB does not represent Dr. Shim. However, ARB submitted an intentionally misleading motion for a protective order for somebody that they do not represent. And within that, the misleading representation, they stated that I failed to properly serve Dr. Shim with his subpoena ducis tecum, when in fact I did. And in fact, the clerk's record will show where Dr. Shim was served by a private process. Nevertheless, with that being stated, and with without notice, Dr. Shim doesn't show up for the deposition. We come into court. ARB defends their fraudulent motion for a protective order, which is actually a sham pleading, because they don't represent Dr. Shim. They stated it so much in the transcripts, and I have all the transcripts from every proceeding, and now I actually have the other one done by Esquire. So I'll just say whether they order it or not, I don't want to find out a year later that they got the transcripts a week later, as we found out with the Huey case. So if just for the record, Ms. Esquire court reporter, please ensure that once they order their copy, and if they don't within a week, please let me know so I can get a copy of this transcript for the record as well. Moving along, this court granted the sham pleading with the understanding that Michael Rowe intentionally misled the court, or I should say Michael Rowe. I'll say the firm intentionally misled the court. That is a deviation from well-established law. That's in the writ of prohibition, and it may be in my motion to disqualify you. Moving along. We get to the second mediation. In fact, of the first mediation, the certificate of attendance and authority, which was required by Rule 1.720, was filed, and he also made notice that the person that was going to attend the first mediation, I can't remember the gentleman's name, but he did work for State Farm. That makes sense. The State Farm representative would have the ability within reason to help Micro, who was made the appearance, or also on basketball, that made the appearance on behalf of the Tuckers to represent the Tuckers in that instance. We move forward. We get to several other issues within this case, many that I have with you all, and I know a lot of it stems from my situation with Judge Holder, former Judge Greg Holder, who falsely accused me of perjury, which we all know I won that case, and I'm in the process of appealing it to the 11th Circuit. But that's just a different issue. Another reason I think that this court, this whole entire jurisdiction, should be disqualified from dealing with me until we resolve that matter. Moving along, when it came to,
I don't know what you're talking about. So
that's fine. That's fine.
let's get to the point.
Okay, the point is, no one other than the ARB made an appearance by rule under 1.720 for the mediation that brings us to where we are now, where you tried to enforce, or actually you didn't try, you ordered me to go and sign a release that had conditions that did not match what we discussed at the mediation conference. You had no jurisdiction over the unrepresented parties, and your order essentially foreclosed matters that were never pled to this court. The fraudulent inducement issue is an issue that did not have nothing to do with this court. When you said you wanted to release the parties, and that release had conditions we never discussed and never could discuss by rule. And it states real clearly, Florida law requires that all parties must, 10 days before a mediation conference, file with the court a notice informing all parties who will attend the mediation conference. And then you go, unless stipulated by the parties, each party 10 days prior to appearing at a mediation conference shall file with the court and serve all parties a written notice identifying the person or persons who will be attending the mediation conference as a party representatives. And you can go to Alvarez versus Citizens Property Insurance Company, go 325 SO.3D 231, 234, and that's the Florida District Court of Appeal. And I'm going to stand on that. So hence, the amount of unethical conduct and attorneys disregard of their duty of candor, again, that doesn't apply to me. I'm not an attorney. I don't pretend to be one. Okay? I read. And candidly, the unethical conduct is one thing, but the court to sanction criminal behavior is almost mind-blowing. And there's no rule, no law anywhere. Nowhere where any court in Florida has ever allowed a court to take jurisdiction of parties that are not properly before the court. The mediation stipulation agreement, had it been just about the Tuckers, we wouldn't be having this discussion, potentially, except for the fact that Michael Rowe's extrinsic fraud in calling a mediation conference when he knew that his underlying desire was to try to get everybody else absolved from their criminal conduct, to include, I think his name is Shabanik, with the Department of Veterans Affairs. I never spoke to this guy and didn't know that he was a VA attorney until after the mediation conference was settled. So I'm starting to find out that, okay, you all were just being unethical the whole dang time. Then I get in front of you, Judge Peacock, and when I argue with Michael Rowe, you stop just short of referring to one of the most racially derogatory terms and tell me that I can't argue my case based on the facts that the court was aware of in your courtroom. So I'll again ask you to suspend, disqualify, or recuse yourself, because you also recuse yourself from an associated case because the same parties are involved, and I don't trust you to do the right thing at all, because you've already carried the water for Michael Rowe's unethical conduct as well as that of his firm. I'll stand on the fact that this court had no personal jurisdiction over the parties who were not properly represented to the court, and I'll stand on the fact that the court had no subject matter jurisdiction over the unpled matters, although your order foreclosed me from pursuing it because Judge Huey, because I don't even know where he was going with it. Judge Huey relied on your order when he dismissed my lawsuit for fraudulent inducement. And as an additional matter, and I want to preserve 5 minutes for rebuttal. As an additional matter, when the attorney went to the District Court of Appeals, they also misrepresented material facts to the Second District Court of Appeals. When the court kept asking me about the transcripts, I wasn't even aware that you all got the transcripts for that hearing with Judge Huey a week later. When I sent the email, and I actually had that email to, I think his name is Wiseman. I asked him, was he going to get the transcripts, and he told me no. I had that in an email, and I'll get that over to you all. But then I find out later on, after we go through the appellate court's proceedings, where you all tried to claim that I voluntarily went into Mr. Officer Rowan Basco's office and voluntarily signed. I probably have 70 objections in the transcripts. So for you all to go in there to the DCA, which is why I'm still in the process of sending this information to the bar, you all knew you were lying to the DCA. I objected, and I still stand on it. I never voluntarily did anything, and if it weren't for Judge Peacock's order telling me to go there, and my fear of contempt because of well, she said she doesn't know anything about it, but my fear of being held in contempt, her order was clear. The rule stated, so long as the order is clear, and I understand that. If I would have disregarded her order, I would have been subjected to criminal contempt of court. That was her order. But her order, again, involved matters that were not played to the court. She has no subject matter jurisdiction, and the matter concerned parties that were not properly before the court, and all of this done under the influence of Michael Rowe as an officer of the court, intentionally misleading the court in some of his pleadings, and deliberately omitting from me what his true underlying motives were when it came to the second mediation conference. The fact that he changed the stipulation agreement and added several hundred more words in the release for things that have nothing to do with January 16, 2017. And on that, I will pretty much rest, because I think I have enough within the record. And to the court reporter, I hope you were able to hear me and gather the information adequately for me.
Okay, who's arguing, Mr. Rowe?
Yes, Your Honor. May it please the court. I'm going to try to be brief, but I have to address some of the topics that have been brought up by Mr. Doss. Obviously, I represent the Tuckers in this case. State Farm is paying me pursuant to the contract of insurance, and that's who my duty is. My obligation was to defend them, get a release, in which I did. The order that the court signed enforcing settlement basically enforced the mediation agreement, which was very specific in who was going to be released, and I'm going to get to that. But the CME issue.
Objection to the first part, just for the record. Go ahead.
The CME issue, Judge, to refresh your memory, is that Dr. Shim performed the CME. He was also a volunteer at the VA hospital, I think 1 day a week. After the CME was completed, totally completed, done, the report was issued, Mr. Doss made an appointment at the VA and wound up walking in to see Dr. Shim.
Objection.
So I don't know what the complaint is. He would have a very valid argument had he seen Dr. Shim before the CME. And then, of course, I could not use Dr. Shim to perform the CME. But that's not the facts in this case. The issue of the deposition of Dr. Shim, all these issues have already been resolved many times over. But the issue with Dr. Shim, there's protective order. One of the issues I do believe was the prepayment requirement. The mediation, there was 2 mediations in this case. And the first mediation we don't have to talk about, but the second mediation that concluded with a voluntary, informed settlement agreement that was detailed and signed, and it was signed that day, the day of the mediation. The only people that appeared at the mediation were the mediator, Mr. Doss, and it was the same mediator who had mediated the first case. And Mr. Doss said he liked that mediator, so that's who we used. And I was there, and the State Farm representative was there, and it was all virtual Zoom at that point in time. The VA did not appear. No representative of the VA appeared during the mediation.
Which one?
The VA
Objection.
lawyer was on speed dial because I knew if I had to resolve the case, I needed to settle with Mr. Doss and ensure that the VA lien was resolved. And I had the person with the authority to resolve the lien on telephone that I communicated outside of the mediation. I can talk to anybody I want to during the mediation process. So this argument that the VA was not noticed to be a part of the mediation, they did not appear at the mediation. So that's another red herring.
Oh, wait a minute. Objection. I have objection.
We're talking about.
Objection.
No, it's not your turn.
No.
Save it. Save it. Go ahead, Mr. Rowe. Finish.
So can I screen share, Judge, if you don't mind?
Yes.
It's my feeble attempt at a PowerPoint. But I just think if we go through the facts that are pertinent to this case, you will conclude that Mr. Doss's motion should be denied. So the auto accidents back in 2017, the mediation that's relevant to this case occurred October the 28th, 2021. It was settled. The agreement was $30,000 to the plaintiff. And in the mediation agreement, that is part of Mr. Doss's motion that he attached as an exhibit, it says that State Farm will satisfy the VA lien. In addition to that, it says that State Farm will pay the total cost of the mediation, another benefit to Mr. Doss, and that the payment to Mr. Doss would be made 20 days after signing the release. It's kind of important.
Objection.
And it's also important to note that
to
this date,
that's not in the release.
he still enjoys the $30,000 that was bargained for in this particular case.
You want it back?
So on March the 28th, 2022, this court ordered enforcement of the settlement agreement. The court relied upon the signed mediation agreement, which is a settlement document. That's the whole purpose of the mediation. After you orally talk, work out all the details, it is reduced to writing, and that becomes the rule of the case. And the rule of the case is the case was settled that day. There was a signed enforceable agreement.
Objection.
The release mirrored the exact language of the mediation agreement of who was going to be released.
Objection.
There's no requirement. In other words, at the mediation, we can bargain for a release of people who have not been sued. There's no requirement that, the only people that can be released and the only issues that can be talked about are the issues of the case. You can go outside of the complaint and bargain for a release of other people. And as we all know now, it was very important that these other people got released.
Objection.
So the order, interesting, the order, and again, I don't have, I have it, but the order basically says that Doss is to sign the release. And if he does not sign the release, there's no talking about contempt or criminal charges or anything else. It says if he doesn't sign, then the release shall be enforceable as if he executed the release. This is important so that State Farm could satisfy the VA lien and pay Mr. Doss his $30,000. The very next day, Mr. Doss comes to my office and says, I want to sign the release. He signs the release. He picks up the check, and there's a transmittal letter that also says exactly what the order says, which exactly what the mediation agreement says, that the following people are going to be released. And so it's written 3 times. One time he signed it on the mediation settlement agreement. The release says it, he signed it, and then it's in the letter which he took with the check. Interesting, on the same day, he signs a release and picks up the money, he files a motion for reconsideration. And I'll save it. 11/7/2022, he does a notice of appeal. The court on that same day, either before or after, enters the order of dismissal with prejudice in the instant case in reference to the Tuckers. 12/20/23, the second DCA issues a PCA saying that Doss loses. 2/9/2024, the second DCA on his motion for rehearing is denied. 2/28/24, the second DCA issues the mandate. 7/3/2024, the second DC issues an order denying the motion to recall the mandate. 1/31/2024, plaintiff files his motion to vacate, which is this hearing right now. This is when he files it, and which is important because he talks about the rules and let's follow the rules and let's apply the rules equally. He missed the time limit. And in his motion, he talks about he's a veteran and somehow he's discriminated because he's a veteran. He complains about the mediation issues. He complains about the VA lien, which was resolved in his favor. He didn't have to pay the lien out of his $30,000. And he talks about the CME issues, which I already talked about before we got to the screen share. Plaintiff settled his case of mediation, and now he wants more money. He's abusing the legal system to extort the Tuckers. The Tuckers deserve to have this case resolved. It happened in January 16, 2017, and here we are 7+ years later, and the Tuckers are still like, is this finished yet? So he's trying to extort the Tuckers, the lawyers
to the characterization,
State Farm,
to the characterization,
all to pay more money. All he wants is more money in reference to this. And note, November 4th, 2022, Mr. Doss talks about the second case, which Judge, you recused yourself. And I believe you recused yourself because in the paperwork, Doss says that you were going to be a witness in that case. So he sues this law firm, he sues Shim, he sues State Farm, and he sues the Tuckers in reference to fraud in the inducement and all these other issues, which are the same issues that were protected by the release, because I knew, given the tenor of this litigation, that if we settled the case and these other issues were not resolved, that we would be facing them. And sure enough, the case settled, and he comes out swinging for me personally, for my law firm, for Shim, State Farm, and the Tuckers. That case was dismissed. He took that up to the second DCA, and I didn't put all the ups and downs on the DCA for that second case, but he went up and down for the DC for that, and it was PCA. The law, not that we need to really talk about that, but we should. But the Florida Rules of Civil Procedure 1.540 paren lowercase b paren 3 paren, he needs to file it timely, and he did not timely file it at all. It's almost, the final order of dismissal was 11/7/2022. The motion to vacate was 1/31/2024, not timely filed, within the year. He has reformatted the same issues over and over and over to the second DCA. It's the same story over and over, the same issues, the same complaints, the same arguments. The second DCA's considered it, reconsidered the reconsideration. The same issues have been before this trial court, I don't know how many times, but the court has considered it, reconsidered the reconsideration, and reconsidered that. And every time it's the same story, that Mr. Doss comes up short because he voluntarily signed the mediation settlement agreement. He was one-on-one with the mediator when that happened. Nobody else was in the room talking to him. In fact, nobody was in the room at all because it was virtual.
Objection.
So the relief sought is that we respectfully request this court to deny plaintiff's motion and impose sanctions. I mean, after 7 years, we deserve some finality. And as we see, he's already filed pleading with the second DCA on whatever issues are remaining in this case. So we'd ask that you deny, impose sanctions, award attorney's fees and costs for the pleadings for this particular issue. And in addition to that, that he be barred from filing any pleadings and no other litigations on these issues, which have been taken up to the second DCA without a Florida bar licensed attorney signing off on the pleadings.
And
that's all I have, Judge, on this issue. Thank you.
All right. Can respond briefly to this issue, Mr. Doss, just the issue on the motion to vacate. Just that.
Okay, Mr. Rowe's characterization of the facts are so far off that you know I'm calibrating. First of all, the fact that he reached out to VA representatives without my knowledge would go to underline his the fraudulent inducement. I didn't have the guy on speed dial and had no idea, and he never represented and all of that stuff is privileged. So I'm going to be careful with that. Although the fraud may underline it all, and you know, it's pretty clear in Westcott versus Westcott that the court noted that fraud, deceit, artifice, or trickery employed in procuring a complaining party's consent to a voluntary judgment or decree entered pursuant to a fraudulently procured agreement is regarded as extrinsic fraud, which would wipe out that 1 year issue. Plenty of case law on that. So it's kind of bothersome to me, and I'm pretty sure to anybody else who will get these transcripts, that you're going to walk in and say, hey, I did everything improper. Forget the rules of professional conduct. I can go up and down that because then I read it. I said, I just can't believe this guy even have the bar license. But at any rate, he's not arguing against the fact that he intentionally kept from me the idea that he was going to try to resolve matters for unrepresented parties. And that, I believe, also was a misrepresentation because we didn't discuss anything that had anything to do with a date other than January 16th, 2017, which is when Chandra Tucker even said in her deposition, I saw you, I rolled stop into your vehicle. I wasn't distracted, and I had full control of the vehicle, which this court said wouldn't even rise to the issue of me arguing punitive damages. If the issue is about the Tuckers, we're finished. That release in this court would refuse, kind of like somebody else to answer certain questions out here in the political sphere, to answer if the release and the stipulation mirror each other. They don't. Hence, I don't know if you're just hearing this for the first time, Ms. McLemore, because I see the look in your face. If the issues mirrored, we wouldn't have a discussion because I don't sign the stipulation because I'm saying, okay, if it's about the 16th, which is what we discussed, without going into all the other details we discussed. And by the way, I would appreciate you, Mr. Rowe, not speaking to what my rights are as a veteran, because I'm entitled to the care anyway. And so we didn't negotiate the lien because I didn't even know that was a part of the issue. A lot of this I found out once I got there because I wouldn't even have shown up. Secondarily, when a concealed fact is material to a transaction, if a contract would not have been entered to but for the concealment, and go to Casey versus Cohen, 740SO2D 59 and 62. And also for the first one, I think I failed to give you the pin site. The Westcott versus Westcott, where the court noted that fraud, deceit, artifice, trickery employed in procuring a complaining party's consent to a voluntary judgment or decree entered pursuant to a fraudulently procured agreement is regarded as extrinsic fraud. The pin site is 444SO2D 495, 498. And also, it's well settled, and this is a Florida court case that goes back as far as time, almost 46. We emphasize that extrinsic fraud on the court includes fraudulent representation of a party without his consent and connivance in his defeat. I'm going to rely on the law, which is kind of strange that the non-lawyer is in here talking about the law. Well, I got this guy who's an attorney talking about everything he tried to do to just keep him being straight up. And candidly, if the Tuckers had 1/10 of the information that I have, they would be pretty irritated. We're still moving forward when they had, which is not necessarily, it wouldn't have been an issue for the jury, a policy that could have taken care of the issue. The underlying issue is Dr. Dr. Shim had a duty to disqualify himself as a CME. And but for the fact that during one of the hearings, an Austin Rowan basketball attorney stated, we've had other cases, unrelated cases, where a patient will treat at the VA, see Dr. Shim, and nobody raised the issue. Everybody in the world knows that if nothing else, there's an issue as a conflict for a doctor, but that violates Title 18 U.S.C. 208, and all I need to do is see that Dr. Shim got one dime from the VA, and that invokes that Title 18 U.S.C. 208. So Mr. Rowe's characterization is way off, and he knows that he's been playing this game from the beginning. We could have easily resolved the issue. My issue for the court clearly is the court foreclosed secondary issues that were not pled that involve parties other than Chandra Tucker and Linda Tucker. That's the issue for the court. And the issue for the second DCA, which was not argued, is did this court have subject matter jurisdiction over the unpled matters? That was not pled to the second DCA because it took me a little bit of time to kind of figure out what was actually going on. And I definitely object to you saying I need to have an attorney represent my interests. And I do have an attorney. We can always call Mr. Morgan.
Okay, so I'm denying your motion to vacate. And the reason I'm doing that is because I reviewed the documents separate and apart from this, and it appears to me that what I ordered was that you signed something that reflected exactly the same words as the settlement agreement that you voluntarily had signed on October 29th. And it didn't matter whether you signed it or not, because the court was then enforcing the settlement agreement. It was the meeting of the minds between the parties that took place at the mediation with, I think it was Mr. Leon was the mediator.
Mr. Burt.
And so
I'm trying to take a note, Your Honor. Hold on.
Meeting of the minds that took place on that date, nothing more. And I indicated that if you didn't sign it, it didn't matter. The court was still enforcing it. And it appears to me that you took the check and you signed it. So, that's it. There's nothing I need to address about the fact that separate liens, governmental liens were discharged in your favor without you paying anything from your amounts. And I don't have any problem with any of that. I think this motion is untimely. And furthermore, I think all of the issues have been at this point litigated in the District Court of Appeal, and my ruling has been affirmed. So there's no new information for the court to review. You haven't it said anything today that wasn't already part of the record in the case. For those reasons, I'm still speaking. I'm denying the motion to vacate for those reasons, and that's now on the record. Okay. What do you need to say, Mr. Doss?
Is it the court's position now, because you did not take that position before, because you said you're not saying that the two documents mirror, that's in the transcript. Is it your position that the release mirrors the stipulation agreement signed at the October, I think, 2021? Was it 21? October 20? It was during COVID. Is it your
29th, 2021?
Okay.
I believe that the release said exactly the same thing that
the stipulation
agreement signed.
Okay, I just want to make sure that that's the court's position, that they mirror each other. Okay.
Okay, thank you. Now, we have one more motion. We only have about 12 minutes because I do have an 11 o'clock hearing. So who's going to argue the motion for sanctions?
One moment, Your Honor, because what I want to do is really quickly, because I wanted to find something. So
no, I want to define anything. I
wanted to show the court
who's
something.
going to argue the motion for sanctions?
I'm looking at the stipulation agreement.
I'm sorry. we're moving on.
Okay, so
Are you-
again, I'll ask you to disqualify yourself. That's
Your
cool.
Honor, may it please the court, Deanne McLemore for the Tuckers. I'll be arguing the 57-105 motion. I know we're strapped for time, so I'll make this as quick as possible. So the defendants, as you know, served a section 57-105 motion on Mr. Doss back on September 5th for this, what we feel is a baseless and unsupported motion to vacate. He did not withdraw that motion within the 21-day safe harbor period, and as such, defendants are now respectfully requesting this court sanction Mr. Doss by awarding the Tuckers their attorney's fees, costs, prejudgment interest associating with having to come here to respond to the motion to vacate and continue to litigate it. Defendants, we filed the comprehensive 57-105 motion. So along with what I'm going to say here today, we're also going to rely on the arguments in the case law in the written motion because it was comprehensive. As this court's aware, under section 57-105, a trial court has the authority to assess attorney's fees, other related costs, and sanction against a party to be paid by the party at any time during a civil proceeding for bringing a claim in which party knew or should have known was not supported by material facts necessary to establish that claim or would not be supported by the application of then existing law to those facts. This includes the filing of meritless, frivolous motions. Here, Mr. Doss knew or should have known that the allegations and contentions in his motion to vacate, they're unsupported by material facts and existing law to those facts.
Objection.
Everything he argued in his motion to vacate is just a re-litigation of fully resolved issues that were before the Second District Court of Appeal twice in two separate cases and resolved by that court's two affirmances. Mandates were issued in both appeals, and those affirmances are final and binding on the parties in this case and this court. He has raised no new substantive issues, facts, arguments not already heard by this court or the Second District in both of those appeals. Therefore, his motion is actually legally barred by the doctrines of law of the case, res judicata, and in the second appeal, collateral estoppel. The arguments he's making have been fully and finally resolved before he filed his motion to vacate, and therefore he knew or should have known that it was not supported by fact or existing law because the Second District already determined these issues. Not only is it legally barred by these doctrines, as Mr. Rowe discussed, it's also procedurally time barred, as this court ruled on under Rule 1.540, which is in the plain language of the rule. Even putting these procedural and legal defects aside on the merits, his motion is baseless, unfounded. It has no support in existing law or fact. Mr. Doss is just wrong on the law as examined by the Second District. This court has jurisdiction over the settlement. It found the settlement was valid. The Second District reviewed that and affirmed. That's the law of this case. He's had the opportunity repeatedly to have these issues heard. He's had his day in court several times over, and the Second District did not agree with him twice. Thus, he knew or should have known that the filing of his motion to vacate was unsupported by fact and law. So at the end of the day, Mr. Doss's motion, his continual and tortuous litigation of these same facts and these same issues that have been fully and finally resolved, they threaten my clients, the Tuckers' right to finality in this case. The Tuckers have a right to have this matter finally concluded and to stop and to not be continually dragged back into the court system to hear these issues again and again that have already been resolved by law by an appellate court. He accepted there was a settlement. We know he accepted benefit of that settlement and it's been upheld. So we request this court to impose sanctions on Mr. Doss by awarding the Tuckers their attorney's fees, costs, and prejudgment interest pursuant to section 57-105 for the Tuckers having to be dragged back into court yet again to defend themselves on the same issues, the same arguments, and the same contentions that have already been resolved in their favor by the Second District. And so these arguments are just not supported by the material facts or existing law at the time. Thank you, Your Honor.
And Mr. Doss, just with regard to the 57-105 motion.
Okay. As to the argument that the motion to vacate was not based on fact, I'll object to that and I'll reduce that to writing because I'm sure we're going to end up appealing this entire thing. what Miss McLemore failed to also mention is that when their deliberate misrepresentations to the second DCA with regards to the our oral arguments. What is a fact is what the issue that was never addressed is whether or not the court had jurisdiction to foreclose the unrepresented parties for matters that were not properly in front of the court. There's plenty of case law on that, and the PCA just affirms the lower court's decision. I will argue whether or not the PCA just kept me from being able to move the case to the Florida Supreme Court. With that being said, I would definitely object to it. There's no issues of fact. There's issues of fact that are clear because they just don't. It just doesn't. That just doesn't ring true. I'm trying to calibrate my language for what Ms. McLemore just said. The bottom line is the stipulation agreement does not mirror the release, but for this court's intervention in forcing me to go and sign a release under the threat of contempt, which is well founded in case law, is inside the not only prohibition but also inside the motion to disqualify, and also Mr. Rose unethical conduct, his fraud on the court on several occasions, also would amount to a denial of my fundamental right to due process of law and the equal protection of the law. With that being said, whatever you rule, I'll just let you know, we'll note it for objection and I'll appeal that as well.
More, anything else?
No, I'll just point out, Your Honor, really quickly that everything he just reiterated factually was before the second district on both cases and resolved by their affirmances. Nothing new has been presented here today. No new facts, no new arguments, no new legal issues. Therefore, again, he is barred by law to bring these again and again and again. And at this point, we would respectfully ask Your Honor to sanction him and award us the Tuckers their fees, their costs, prejudgment interest for having to come back and say this again. Thank you, Your Honor.
Okay, so I'm going to grant the motion for sanctions for the Tuckers in defending the motion to vacate. That's the extent of it because that's all that you requested. So I'm granting entitlement. You can file affidavits with the amounts, and if we need to have a separate hearing on the amounts, if you all can't agree to that, I'm guessing that you won't be able to. We can have a hearing on that, but
and I'll object to that as well.
See what happens. I'll grant the entitlement. Okay.
That's fine.
All right. Great. Thank you very much.
Okay.
Thank you.
Thank you, Your Honor.
Ms. McLemore, will you do, and Mr. Rowe, can you all do orders on both motions today so that those are in the file for Mr. Doss? Separate orders.
All right. And also,
When would you like those orders by, Your Honor?
Pardon me?
I'm sorry, Your Honor. When would you like those orders by?
The next few days if you can. Make sure Mr. Doss sees them. If he objects to the form or content, then I need to know that.
that'll happen. By the way,
Thank you.
Mrs. The court reporter, ma'am, is it possible that you can give me your number, Esquire?
I work for Veritex.
Oh.
Veritex.
Oh, I'm sorry, ma'am. Veritex.
You can call Veritex. Her name was Annie Beilstein, Beilstein. You could call Veritex if you want a transcript.
You got a number to Veritex?
I don't have it offhand, but
You can Google that. You can
I
Google it.
want a copy
Okay.
of the transcript. Thank you, ma'am.
Deanna, give me a call.
So, as we saw and heard, and I will definitely make available for everybody out there, not only the transcripts from the case, which was so bastardized inside this hearing, and I had to definitely move lightly because I'm pretty sure that Judge Peacock, because I've filed about 5 motions to disqualify, probably is really hot with me right now. But what I would definitely show to you all is that the stipulation does not mirror the release. And you all can do your own research as to whether or not a court has subject matter jurisdiction over matters that were not properly pled. You see that being, and I'll definitely object to, and we'll be appealing these issues for sanctions because we didn't argue the issue of whether or not the court had subject matter jurisdiction to resolve matters that were not properly in front of the court. because it's peppered all over the motion to disqualify. The case law that says the court generally doesn't have jurisdiction over matters not properly pled. She foreclosed my ability to file a lawsuit on those matters. So with that being said, as you see, it's not an easy thing. And anybody have any thoughts or questions or comments, please feel free to leave them in the responses. And also, if you know a veteran or any attorneys that represent veterans, bring this issue to their attention that this court allowed a attorney to solicit the aid of a veteran doctor. And we don't know if he's an employee or not, or a volunteer, because we don't know if the VA ever gave him any money. But if he got a benefit, that does not exclude him from the consequences of Title 18 U.S.C. 208. That being said, appreciate you all checking out the video. Y'all take care.